All right. Good morning, everyone. Welcome. My name is Gail Eisenhauer. I am an education consultant with the Wyoming Department of Education. I appreciate you tuning in for this session today on out-of-district placement guidance. Before we get started, I want to introduce Margie Robertson. She is the Division Director for the Special Education Programs Division, and she has a few words for you.
Good morning, everyone. Thank you for joining us for this very important training. I wanted you to know that over the past 6 to 9 months, WDE, specifically led by Gail Eisenhauer, has worked to produce a comprehensive document to clarify both the federal requirements and WDE's or Wyoming's expectations for the provision of services and IEP responsibilities for students that are placed out of district. I want to thank Gail for all of her hard work and the attention to detail that Gail always brings to every project. She has worked with our team, our out-of-district service providers, special ed directors, the WDE data team, and even the AG's office to make sure that we have given you the most accurate and helpful document possible. It probably won't be perfect. You'll probably give us feedback that we'll take back to the table and continue to make this better. But I think we have a very solid and well-written document for you. And really a big kudos goes out to Gail because she did all the work on this. And so thank you so much, Gail. We hope that you find this document helpful. We hope that this document means that children that are placed out of district who we know are at great risk have better outcomes and more protections. And we hope that you find this training very meaningful. So thank you again for joining us today. And a big thank you to Gail.
Well, thank you, Margie. That's very nice. A couple things before we get started. One, a recording of this session will be available in a few days on the WinWeb Waves, under the Waves button on the WinWeb website. And the other thing I was just thinking of it, two things. Oh, in the chat, there is a link to today's session materials, which is just a PDF of the PowerPoint that I'm going to present. So you can check that out. Okay, let's get started. Oops, sorry. Okay. So this guidance document was initially posted in July of this year, and we're going to review it actually page by page. There is a link there to the actual document, but I want to show you, I know we have a lot of new SPED directors this year, and so I kind of want to walk you through how to find this on our website. So if you go to the Wyoming Department of Education website, which is edu.wyoming.gov, you'll see our main web page. And up at the top menu bar, there's a selection called For District Leadership. And that brings up this list of different places you can go. And one of them is special education programs. This can be kind of difficult because I know when I'm working on my laptop, the screen isn't big enough to get all the way down to special education programs. So I have to manually scroll down to find it. But if you go to special education programs, that brings up our special education page. And on the right side of that page, there's sort of a gray bar of quick links, and under special education programs, there is a selection called Technical Assistance and Guidance. That brings up our TA guidance page. And if you make it to that page, you'll see under guidance documents, this out-of-district placement guidance is at the top of the bulleted list. You'll also find other guidance documents on things like parental placements in private schools and homeschools, ED or emotional disability, child fine and eligibility guidance, developmental delay, eligibility guidance, and much more. So that's how you get to our guidance page. And the link, the direct link to that page is listed in the PowerPoint. So starting with page 1 of the document, it is divided into 3 sections. One is IEP team placements. Then we're going to talk about court-ordered placements, medically necessary placements, and there's an appendix at the end of the document that outlines out-of-district placement responsibility for FAPE and how these different placements are funded. So beginning on page 1, what I'm going to do throughout this presentation is just point out some of the most essential elements and some things that may have changed from the way things were done historically. I'm not going to cover every word of the document. You can read it yourself, but I'm going to talk about what I consider to be the most important elements. So on page 1, there's a continuum of alternative placements under the IDEA. And on the far left side is the general education classroom, which is considered to be the least restrictive environment. That's can be comprised of students with disability, non-disabled students. It's the least restrictive. And moving to the right is what we typically refer to when we're coding as resource room, but that's an environment where students spend between 40 and 79% of their school day in the general education environment. And that includes things like specials and lunch and things like that, recess, etc. And then moving to the right, the third one is self-contained special ed classroom, which is a greater percentage of time spent away from the gen ed environment. Then we have separate school. Next to separate school, moving to the right, it says residential treatment facility. And then it says hospital or institution. Then it says homebound, and then it says detention facility. Over the years, we've had a lot of questions about, is placement in a residential facility, is that actually less restrictive than if we put a child on homebound? Do I have to order a child to a residential facility if I'm moving incrementally on this continuum before we place them on homebound? So the answer to that at the top of page 2 is like the answer to many questions in special education. It depends. And I'm just going to give you a brief explanation of why that is. So for a non-disabled student, a regular classroom placement has 2 main components. One is the student interacts with non-disabled peers, and 2, that the student is attending school in the community in which he or she lives. So if you're considering a student and thinking about the LRE continuum, if you're considering residential placement, if it's more critical for the child to be in a residential treatment congregate setting with other children, then the residential placement is considered less restrictive than homebound. But if you have, for example, a medically fragile child and attending school in the community where the child lives, where the hospital is, where the doctors are, where the parents are, if that's the primary consideration, then homebound may be considered less restrictive. So it's not necessarily one or the other. Most of these continua show residential treatment as less restrictive, but they are interchangeable depending on the needs of the child. So The next thing I want to talk about are things to consider, things that a district team needs to consider prior to IEP team placement. And those are things like, have you made, significant inclusion efforts to include the child? What are the comparison of likely benefits? Will the child benefit by staying in your school with supports versus placement? What mainstreaming efforts have been made? What physical or emotional conditions exist? Behavior, prior assessments. Have you done all the necessary assessments? Thinking about and reflecting on the child's past experience and the purpose of the placement. Also on this page, it talks about the fact that behavior problems may not be the sole basis for placement unless they become really severe. And placement can't be based solely on personal issues like relationships with parents or family, gang affiliation, or violation of social norms, truancy, things like that. Whoops, sorry about that. So on page 3, it talks about the district's responsibility for IEP team placements. And I'm just going to run down a bulleted list of things that the district is responsible when they place a child, when an IEP places a child in a residential facility. The first one is adding that residential treatment facility staff to the electronic records management system, if you have one. If you're using an ERM like SPED Advantage or whatever, adding staff to that so that they can enter progress and have access to the students' information. The next thing is to initiate action to develop the IEP, to schedule the change of placement IEP meeting, to send notice of the meeting to appropriate parties, to collaborate with residential treatment staff to develop the IEP. This is very important. And you will hear me throughout this presentation stress the importance of collaboration between the district and the facilities staff over and over. And that's on both sides, need to collaborate. To provide procedural safeguards to the parents, to conduct the IEP meeting, to write and disseminate the IEP, to complete prior written notice. Okay, so these are all district responsibilities. And aside from bullets number 1 and bullet number 5, which are in black print there, historically in Wyoming, many of the actions listed in green have been performed by some of the staff at residential treatment facilities. You can reflect on your own district and how you do business with residential facilities. But I know that there are several new directors. And so I want to say some of this may feel like a change for some of you, not all of you, I'm sure. But the guidance that we're issuing is that the district is responsible for every one of these tasks. And whether or not the district chooses to do them themselves or delegate some of these responsibility to the facility, that's your call. But ultimately, if there is a breakdown in the chain of IDEA tasks that need to be performed, the responsibility lies with the district. And so this is why we're issuing this guidance. There has been a lot of confusion over the years about, for example, who needs to conduct the meeting. Some people say it's the facility, some people say it's the district. I've had calls from facilities saying, you know, District X wants to write the IEP and conduct the meeting. I've had calls from districts saying, shouldn't the facility be doing this? Hopefully this guidance will clarify. It is the district's responsibility. However, I had a great call from one of your colleagues last week, and this person has worked with an individual in one of our state facilities. And she said, you know, I'm okay with her writing the IEP. I review it before the meeting. That's the way we've done it. We're good with that. That's okay. But keep in mind, it is the district's responsibility. And if it doesn't get done, or if it gets done incorrectly, if there's a problem, it comes back square on the shoulder of the district. And that's also assuming that the facility has the capacity and the expertise to do what is being asked of them. So it's very much a two-way street, but ultimately, again, the district is responsible. Also, the district maintains responsibility for evaluating student progress reports to ensure that the student's making adequate progress, obtaining consent for any evaluations that may need to be conducted, developing an assessment plan if necessary, and conducting required assessments or arranging with a third party to conduct assessments. So basically that covers district responsibility for IEP team placements, and also accurately reporting student data on the WDE 684. And we'll talk in more detail about that in a minute. On page 4, I just want to note a couple of things. One is that the district, throughout the placement, the district should remain the parent's primary point of contact for all things related to the IEP. And the district also retains responsibility for the online records. So, you know, having the responsibility also, we want to ensure that the district is not out of the loop in any way with what is going on with the child throughout placement. So now we're going to talk about the residential treatment facility responsibilities for these IEP team placements. And this is whether a student is placed in state or out of state. There are certain basic responsibilities that we expect of facility staff. And those are to notify the district of the child's arrival at the facility, to collaborate with the district to develop the IEP, very important that the facility has input into what that IEP is going to look like, since they will be implementing it. To assist in providing procedural safeguards, if that's what the district requests. To assist in conducting the IEP meeting, if the district requests. To assist in writing and disseminating the IEP. To monitor student progress on annual goals and to disseminate progress reports. And to request that the district reconvene the IEP team if the student is not making adequate or expected progress. Also, if there are additional assessments or if it's time for reevaluation, the facility would work with the district around that and work with the district on additional assessments as necessary. So I said we would talk a little more about data collection. There has been a lot of questions over the years about how do we code these kids. I worked with WDE data team, and for students that are placed by an IEP team, they're saying that the concurrent enrollment should be no. that you need to list the service school ID. Every school has a service school ID. If you can't find it, if you don't know it, if it's an out of state, use the contact number that I provided there and they will assign one, but you need to enter something for that. Also, I know that the approved in-state institutional schools at least are, and the service school ID are listed in the WDE directory, so you can find it there. The student environment would be RF for residential facility, and the exit type would be null 469 placed in an institution. We don't want to see transferred out or dropped out or any of those codes that don't accurately reflect the status of a student that's been placed by an IEP team. So before we go on to the next section, which is court-ordered placements, I want to pause for a minute, and if any of you have questions about IEP team placements, now would be a good time to ask those.
Recording in progress.
I think you can just unmute your microphone and speak if you want to ask a question. No questions? I must have covered that really well.
I might have one question.
Oh, I didn't cover it that well. Go ahead.
When would the exit code be used? The student would still be enrolled in our district, wouldn't they? We're still putting them on the 684. I guess we're confused when we would use that 469 error code or exit code.
Let me go back to that slide. Yeah, you still have primary enrollment. So I'm not a data person. This is just what they gave me. So I don't know why you would use it or why they said that, but the district still has primary enrollment for sure. And you're recording the student on a special education file. So you would note the environment is residential facility. So
after I think about it a little bit, what it probably is it would be a second line of enrollment. We'd end one when they were leaving the district with a 469, and then we have a new enrollment for the out of district placement.
That makes sense.
I'm looking at my data, Gail. She's slowly nodding her head, thinking that might be what it is. So, okay, thank you.
Sure, thank you for the question. Any other questions about IEP team placements?
I have a question. We do have a little bit in the chat as well.
Okay.
One of them says we will now be gridding medical.
Let me look here. I'm not sure what that means. Gridding.
So when the kids we've placed at St. Joseph's, when St. Joseph's writes their IEP, some of the services and related services are nursing services. It's different than what we would be providing in the school. And so that would be a new, we would have to learn how to do that or how we would write that in under the related services portion.
So here's the thing. This is why the collaboration piece is so important, because a student may require services in the residential setting that they maybe didn't require when they were attending public school. That's a conversation to have between the district and the facility, right? But what we don't want to have happen, okay, is that a student goes into a residential setting and there's this full menu of services, related services, special ed services that the facility says, well, this is just our standard program. Again, remembering that the responsibility for FAPE is on the district, that's a conversation that you need to have. And ultimately, you need to either come to consensus or the district needs to make a decision about what that IEP should look like and what the child needs in order to receive FAPE. Because at the end of the day, that's the purpose of placement by an IEP team is, so that the child can receive FAPE. So what I'm saying is, that's just a collaboration, a conversation that needs to happen between districts and facilities. And what you end up with at the end of the day, neither side really should say, this is how we do it, or this is how we do it. It needs to be a true collaboration. Does that make sense?
It does. It's just different than what we've done in the school setting. So, but that does make sense. Thank you.
Sure. Oh, JP.
Another question. It just said, is the code 469 counted as a dropout or a transfer or counted in the district count?
It's not counted as either a dropout or a transfer. It just means that the student is, physically in a residential treatment facility. However, it is counted in the district count that they remain a student with a disability that is has primary enrollment. I apologize. My little dog heard the mailman there. So thanks for the question, JP. And then Dawn, it looks like you said our 413 contract specifically, I think you didn't specify the duties of the receiving agency. I want to talk about the 413, and I think there's another one, is it the 406, a couple of forms that came out of WDE back in the 90s. Coco, stop, come here. I think they were done in like 1995, 97. And Margie and I have looked into those with Trent Carroll, who used to be the head of finance and is now the chief operating officer. And those forms are not valid. I mean, let me back that up. Those forms are meant to be used as more of a template. And I know that many of the districts have customized those forms in different ways to reflect, what you want them to see. They are not official WDE forms. So in a sense, there's no contradiction, because Trent said he can't even find any record of those forms. They were put out many, many years ago. He can't even find a record of them in the archives. So you can disregard essentially that part of it. And again, I said historically, it looked very different from what I'm telling you today, right? Historically, I think the residential facility took on much more responsibility for the IEP and different tasks, but what is listed on that old form, it's really meant to be, at this point, more of a template. It's not an official WDE form that we require. So Dawn, I hope that answers your question.
It does, and they're very old. They're also what our auditors look for. So we should probably be working with our we should probably be working with our financial people too, because right now that is what our auditors look for.
Yeah, I would customize.
And then just as you were saying, like to specify, I mean, like you said, yes, ultimately the districts are responsible for those pieces, but you also mentioned that we need to work with them and decide to who's going to do what. And that's why we clearly delineate that in our contracts when we make contracts with places like BOCES or other outside agencies.
Right. That's a good point. So I would just urge you to customize that form. Think of it as a template and get rid of that old language because that doesn't apply anymore. And, you know, there's a lot of stuff floating around on the internet or in people's files out there. And we have found some contradictory things. And as we find them, we are working to clean them up. So we want to have a consistent message for sure. And, you know, this is one of those things that the guidance, I think, gives you a clear path to what you need to be doing. And Don made a good point. That's not that you can't contract with others to do it. And if they have the willingness and the ability to do it, that's fine. That's between you. Margie made a comment, educational need must still be considered as you design the IEP. If the service is the service necessary for the child to receive FAPE based on current and individual needs. That's a great point, Margie. Okay, so now we can talk about court-ordered placements. So court-ordered placements in many ways are very similar to IEP team placements in terms of the district's responsibility or in terms of the facilities responsibilities. One thing, though, that is different, before any child is placed by district court in Wyoming, there has to be a multidisciplinary team meeting through the county, through the court. And statute says that a mandatory member of that multidisciplinary team that will make a recommendation for placement if placement is being considered for a child. For all kids, there needs to be a representative of the child's school district who has direct knowledge of the child. But if the child is a student with a disability, receives special education, it has to be a member of that child's IEP team. And that's because we don't want recommendations being made to facilities that don't have the ability or the willingness to provide special education, right? So somebody on the IEP team, it can be, I don't know, you know, how you structure your IEP teams. It could be the district rep, it could be the special ed teacher, it could be a gen ed teacher. The parent is also a mandatory member of the MDT. So that's the reason for that, is that to ensure that whatever placement recommendation is made, that it's appropriate to meet the child's special education and related services needs. And then on page 6, before we go to that, I just want to say, aside from that, all the responsibilities of the district are the same as what we reviewed for IEP team placements. So assigning the electronic record, initiating the IEP, sending the notice, and that those are all lined out in this document. I'm not going to take the time away from this to repeat all of them, but basically, once a child has been court ordered, your district responsibility is the same as a child that you place through an IEP team, aside from funding, which of course, if it's placed by an IEP team, you would receive 401 funding for the cost. If it's placed by court, the facility bills WDE for educational and special education related services costs. So when we talk about resident district responsibilities, ensure that a member of the IEP team serves on the MDT. If that isn't happening in your county, I would urge you to contact your district attorney or your county court, juvenile court representatives and talk about this, because this is very important. Resident district responsibilities for court-ordered placements are essentially the same then as they are for IEP team placements. At the top of page 7, there's a statement that says court-ordered placements occur throughout the calendar year, including periods when schools are not in session, like Christmas or winter break or spring break or summertime, right? The courts, it doesn't matter. They can occur anytime. And IDEA timelines still apply. So be sure that you have a designated district person, district rep identified to fulfill the resident district responsibilities during those periods. If the need arises during a break, there should be somebody, and the court should know who that is, that the facility can contact to make sure that these things happen. We don't want a student with a disability waiting for 2 months or 2.5 months, whatever, on an IEP. That can't happen. You need to have a designated district rep, and the district attorney needs to know who that is in case there's an MDT during those breaks. Again, responsibility for reevaluation remains with the district on court-placed students. Responsibility for child fine remains with the district. If a student is ordered to a facility, a non-disabled student, and there's some question as to, perhaps this is a student with a disability, the district is responsible for comprehensive evaluation, just like you would be if the child was physically in your district. Again, on the data piece, pretty much the same, no to concurrent enrollment, service school ID. The environment for these students is CP, court placed. And again, if an exit type does apply, it would be null for 69. The residential treatment facility responsibilities for court-ordered placement are the same as for IEP team placements. And that list is in the guidance, but basically there's no difference. The facilities do bill WDE for educational costs. And there is another caveat, not a caveat, but there's in statute, it says if any time a child's placement is found to be educationally inappropriate or not the least restrictive placement available, the district should notify the child's DFS caseworker or the county district attorney for referral back to the court, along with a recommendation on what would be a more suitable placement. So if you're an IEP team and you're placing a child and you find out that the facility does not provide special ed, the child isn't getting FAPE, you would call back that contract and you would find another placement. With a court-placed student, you still have some recourse, and that's why this is in statute. So if the court places a child, hopefully if you have a member of the IEP team on the multidisciplinary team that recommends placement, this won't happen. But if the court places a child in a facility that says, we don't do special ed, this is treatment, for example, or whatever, if it's educationally inappropriate and the child isn't receiving FAPE, you can take it back to the court, and it's recommended you go through the DFS or the district attorney and say, this is not okay. The child isn't receiving FAPE. This is what we've done to, make that happen, but it's not working. And then they would take that under consideration. So at this point, I will pause for a minute. Questions about court-ordered placements?
Hey Gail, it's Steve Slyman. I put it in the chat, but I just want to make sure that we're doing things correctly through the court-ordered placements. So we would maintain, for example, we would maintain the student in SPED Advantage so we can share records with the treatment facility, but we would transfer them out from our student management system such as PowerSchool so that they would no longer be counted there. Is that correct?
Well, I can't really speak to the ins and outs of those different student management
Well, it's really a
systems.
funding issue because if they stay in PowerSchool, then we would still be getting ADM for them.
Oh, well, you can go into PowerSchool and reduce the ADM to 0%.
Yeah, that's true. I'm just wondering which, so we can just pick and choose what we want to do then.
I think so, yeah.
Okay, thank you.
Gail,
Thanks,
if I
Steve.
could, this is Margie, if I could just add, I know we had some discussions and I would say our preference would be that you would keep the kid enrolled and reduce the ADM to 0%. And I'll tell you why. Because the ultimate goal is that the student would return to your district. And that allows you guys to maintain that particular record. But again,
Yeah,
I don't think
that's fine with me, Margie. I got you. We just have inconsistency across the district with how we're doing it. And I would just like to get us all on the same page. So I really appreciate that. We will keep them in there. And I can tell you, administrative assistants, the kid's not there in school for 10 days, they're popping them out of there, and I'm wondering where they went before, because sometimes they know about them not being in attendance at school before I know they've been court ordered somewhere. So it's a process, but we'll get there. And I appreciate your work on this. Gail, especially. Thank you.
Thank you, Steve. Good question.
Gail,
I'm sorry.
Hi, Gail. I have a question too. I actually put this in the chat box as well. Just as it relates to obligations under child find, because when you have a court order placement, oftentimes they are evaluated by whatever team of the facility they go to. And
Right.
obviously it's not the same evaluation that we do for special education. Typically does not involve the same instruments. But when they come back with a diagnosis on a student, they say, oh, this kid has ADHD, this kid is depressed, this kid has anxiety, PTSD, whatever. Would that be a hallmark when the district gets it, that then our obligation under child find starts, so that if they are finding a disorder and they're diagnosing a child with something that's going to need a treatment, because that's what they're going to be working on, are we obligated then to start our child find process to evaluate for special ed?
Great question. So it definitely could be one of those triggers that would make you consider whether or not comprehensive evaluation is warranted. If a parent requests that the child be evaluated, if the facility requests, that's the beginning of a conversation, right? There's nothing that says, a diagnosis automatically equals evaluation, but I would say, things like that could be big flags, right? That maybe that needs to be considered. And certainly if a parent requests it. But no, there's no automatic obligation based on, finding of a diagnosis. That's the district's call.
Thank you.
Sure. And Dawn, you had a question about tribal court doesn't invite you to the MDT. I don't know if they even hold them most of the time.
Sorry for my crazy typing. Yeah.
That's okay. I'm sitting kind of a ways back because I have that wonky computer thing.
I can't type and think at the same time, evidently.
So this is a tough one, Dawn, and we've talked about this before. The guidance that we're putting out is based on Wyoming statute, and which includes district court procedures, tribal courts. And I know that they can and do place students, but they're not bound under the same statutory requirements. So, all I can say is, you said we've tried to inform them of the importance. We need your help to get this in place. Margie, maybe this is something that we could address, with some of the members of that community as far as the importance of this for IDEA.
Yeah, Dawn, I will bring this back to the AG's office and talk to McKinsey about what the Department of Education could do to communicate this to the courts, because we definitely feel the frustration and the difficulty, because we know you're trying to do the right thing by the kid and be involved, but if you don't know, so we will do what we can.
I think for the most part, we have pretty good relationship with people, and we have a resource officer. I think most of the districts do, and but there isn't that really clean process of we're being invited to MDT meetings, and there's nothing like that. It's more like, oh, so-and-so ended up in Busby, Montana over the weekend. You better give them a call. I mean, that's kind of how it happens. If there's I know that Brooke's on here. I don't know if she has feelings about it, but that's kind of that's sometimes how we find out about some of our students being placed.
Thanks, Dawn. And Mackenzie just piped in the chat, and I know this, and this is my mistake for referring to this as district court. Keep in mind that these are all juvenile court matters, not district court. It's confusing since they are the same judges, but they are distinct with different jurisdiction. And he's right, they are. This is juvenile court. I think of it in terms of district court, but juvenile court is correct. Okay, so.
Gail, I had a question.
Oh, sure.
I guess a statement maybe.
Sure.
I think in looking at that statute that indicates that an IEP team member should attend all MDTs. I think on paper that's a great idea and it makes sense. In the world that we live in, the actual world, we have MDTs every Tuesday and Fridays of every week, all year round in our county on kids that are placed or kids that are, to see about having an IEP team member attend every one of those, I think is a bit of a stretch. It's not that easy as it states on a piece of paper that they should. We have a district representative that attends all of those. I find that, for larger districts, I don't know how feasible that can actually be, to have someone from the actual IEP team attend all of those. I feel like when districts are placing kids, there's a lot of communication that happens with those placements. Those are fairly simple kinds of collaborations that are happening. Court order are a whole different ball of wax in that the judge can decide whatever the heck they want to decide, whether or not the kid has needs. And so, I mean, I'm sure all residential treatment centers right now are just excited that this has removed any and all obligation from them and placed all responsibility on the district, which I understand IDEA has that. But, these are, I mean, we have a lot of students and it's very difficult to keep track of. I mean, so I'm going to call in residential and say, I need your present levels of performance, run that through my compliance department. My compliance department's going to say, this doesn't have enough. So now, since I don't supervise that person that works at the residential statement or residential placement, I'm going to be going back and forth with that person saying, oh, I need more. Your goals are not measurable. I mean, it just becomes a nightmare. And I've done this long enough now that it happens. Some placements are very good about it. Others, it becomes very complicated. So I feel like, again, it may just be a venting, and I apologize with all the people on here, but there is things on paper that sound good, and then there's the world we live in.
Yeah. So, to your point about the MDT, I would say, if a member of the IEP team can't physically be in the meeting and you have a district rep, it's just super important that district rep has information about the child's special education and related services needs so that they can convey that as if they're considering a placement recommendation. And you're right. You know, I too have attended a lot of MDT meetings over the years. And, you know, generally what the team recommends is what the judge does, but not always. You know, there can be, you know, some errant placement at the last minute, and we can't really prepare for that. So I'm not saying that what this guidance recommends is 100% foolproof, but this is maybe your best bet. And yeah, communication and collaboration takes time. It does. You're absolutely right.
Gail, I've got a quick question.
Mhm.
Maybe not quick. I hope it's quick. I've never experienced a child find situation when a general ed student has been court ordered to a facility, and then for however that's brought up, whether it be a parent or somebody at the facility recognizes a suspicion of a disability. What does that honestly look like from the district's point of view to truly conduct an evaluation, a thorough evaluation, if and heaven forbid if it's in Florida and I'm here in Evanston, or even across the state in Gillette or whatever it might be. I mean, really, how does the district conduct a comprehensive evaluation when a student is in a facility like that? Is it just a bunch of money swapping of, okay, I'm going to hire this psychologist, I'm going to hire this person, I'm going to hire that person? And I never even see it.
I would say generally, yeah, it's contract for services. I mean, you know, the district always has the option of sending people to the facility, but I don't know that that happens very often. Yeah, it would be a matter of contracting for services to get the required evaluations. Generally, in a treatment facility, you can get, you know, a psych eval if they have a school, and hopefully they do. You know, you can get observations, and you can do parent interviews, things like that. So it's a matter of contracting with qualified people to perform those assessments. And that may include people at the facility. The district may choose to do part of it themselves. That's a district call.
And is that all then billable to the WDE or the state that way, or does that component fall on the district?
So if, you know, we would have to check with finance. Those of you who've been around a long time may remember Terry Frazier, who used to handle COPS billing, and then it was Jennifer Gregory, and now I think it's Joy Harris is doing it. And the last I heard, some of that is billable to WDE, and we would have to just check to make sure which parts of it WDE pays for evaluation or reevaluation. I don't want to say, you know, I don't want to make a blanket statement because I'm not 100% sure, but that's something I can.
If there's a list or there's a guidance document on that, that'd be awesome. I'd love to see that. And again, I've just never experienced that level of child find.
Okay.
Yeah. And Gail, if I could add, this is Margie.
Yeah, Margie.
While we can't speak specifically to what COPS would or would not allow a facility to bill WDE, I can speak that your federal funds can be used for child find. So you absolutely can use some of your federal dollars to contract and fulfill your child find obligation. You also can be reimbursed on the 401 for child find activities. And so the district has two ways for certain that they could fund and fulfill this obligation. But we can absolutely also look into if the COPS program for a general education kid. My guess is that the answer would be no, probably not for COPS, because that child doesn't already have an IEP.
You know what, as I thought about it, Margie, and thinking about some of my experience with finance over this, they do have to have a valid IEP in order for the, I guess, reevaluation costs to kick in. So child find would be on the district with federal funds or 401, I think.
Yeah, and I just would like to follow up on Alan's comment earlier, and I think it was Matt that asked the question that, WDE recognizes that this is hard and difficult work, that this isn't easy for the district. The obligation didn't change. The obligation to fulfill IDA always fell on the shoulders of the district. However, we just have aligned the procedures and the practices to be in line with that, and really to make sure that we were making the best, setting up children for the best outcomes. And I think the old practice in some cases was not working for some districts or some children. We became aware of kids that fell through the cracks, of kids that came back to districts without educational goals, of districts calling and saying the courts have placed a kid in a place that doesn't have educational components. All of those pieces were taken into consideration, and we certainly will work with districts at trying to provide whatever support's necessary through clarification with the courts. But we really came at this from the perspective of what is going to be in the very best circumstances for kids that are most at risk in our state. So I just want you guys to know that is the perspective we took. We weren't trying to make it hard on districts. We weren't trying to increase obligations in an already difficult world. We were just really attempting to have those practices align with the expectations and improve outcomes for kids.
Thank you, Margie. Okay, I am running out of time, which I knew I would, but we've just got a little bit left. So real quickly, I'm going to talk about medically necessary placements. And I don't know if any of you have had experience with this. This is something Wyoming statute 21-13-336 was enacted, I believe, in 2016. And if you haven't, I think at some point you will have, because this is a growing number of Wyoming students being placed this way. So when a child is placed by his or her parents in a psychiatric residential treatment facility, a PRTF, and the Department of Health, Wyoming Department of Health, has determined that the placement is medically necessary under Wyoming statute 424103, which means it's a Medicaid qualified placement. The resident district still maintains primary enrollment of the student and responsibility for FAPE, even though the student's placed by the parents. Okay, so that's important to know. If a child is placed in a PRTF that has been approved by the Department of Health, within 7 days of receiving notice from the PRTF, the district has to notify the PRTF of the manner in which educational services will be provided to the child. The district will either request that the facility provide educational services to the student, deliver educational services directly to the student, or contract with the district where the PRTF is located to provide those educational services to the student. Now, I want to make a point here. The statute doesn't specifically address special education. So we've had a lot of questions about this. In fact, this summer, we had a question about this, and I want you to know that it could be some type of hybrid situation where the facility provides the basic educational day and the district chooses to provide, special ed services virtually or whatever. So it could be a combination of that. So what we're saying is the district makes the call. In Wyoming, I believe, and I don't want to misspeak, but the only two PRTFs that I'm aware of are St. Joseph's, certified as a PRTF, and WBI, I believe, but I could be wrong about that. So you would decide, you get notice, you'll most likely get a letter from the facility. Child's been placed under this statute, medically necessary. How do you want us to provide services. And if it's a child with a disability, you know, in general, I would say the facility provides the service, the facility provides special ed, but you do have some options to customize that. In the case of school district responsibility, again, same responsibility while the child is in that placement as applies to IEP team placements and court-ordered placements. Resident district responsibilities also the same. In addition to sending that letter in the beginning, same basic responsibilities for the child's placement. I'm sorry, I think I got ahead of myself. Okay. So data collection, I want to let you know that right now, this moment in time, the student environment that districts have been coding for these students has been HH, hospital or homebound. In working with the WDE data team, I've been told that that's going to change and there's going to be a new designation option of MN, medically necessary. So you might look for that. They work pretty quickly, data, and for the coming 684, you might see that designation. And if you have a student like this, that would be how you code their environment. Any questions specifically about medically necessary? I don't want to run over, we're about out of time, but I'm willing to stay on the call. If any of you have questions, let me do this real quick. There's an appendix at the end that outlines each type of placement and different options for placement. So for example, if it's placed by the IEP team, the district maintains primary enrollment. The district is responsible for FAPE. Let's say the educational services are provided by the facility as our IEP services. There would be no ADM for that student, but the district could bill to 401. There would be no WDE comps, it wouldn't apply. And that's a description of the situation described. I'm just going to outline a couple. Under court ordered, the resident district maintains primary enrollment, responsibility for FAPE. Let's say services are provided by the facility as our IEP services, no ADM, no 401, and the facility would bill WDE directly for the cost of the educational day and IEP services. Medically necessary, I kind of threw a curve on this one. Let's say the resident district, you maintain primary enrollment, responsibility for FAPE. The PRTF will provide education services, but let's say the district wants to provide IEP services for whatever reason. There would be no ADM. The district could bill 401 for the special ed services and the PRTF would bill the department. But this chart lists many different scenarios. If you have a question about responsibility for enrollment, FAPE, and funding. And there is a link to evaluation. All of you will receive a follow-up email with this link. This is my contact information. And I just want to say before we end, because I know you're busy, but I will stay on the call if anybody has questions. Thank you to those of you who provided feedback when we first issued the draft document. Thank you. Many of you who are on this call have called me or called Margie or called Susan and asked questions about out-of-district placements. It was those questions that really became the foundation of this document. If you have any questions at any point, feel free to contact me or Margie or Susan, and we'll do the best we can to help figure out an answer for you for those questions. I appreciate everybody taking the time to attend this session. Thank you. And with that, I will close. feel free to leave the meeting, or if you have questions, let me look at the chat, put them in the chat or just unmute and I'd be happy to address them.
Gail, I did capture a few of the questions that were unable to be answered, and I'm gonna just throw those in an email to you so that it could be followed up as well.
Okay, and I don't know, if Dawn, you're still on, but yes, I will ask Joy to send that list to everybody.
Thank you. Yeah, we used to get at least like quarterly
Okay,
updates or something. I can't remember exactly the time frame, but it was good. You could catch mistakes if kids
Yeah.
were assigned the wrong district or something
Yeah.
like that.
I remember when I forget, was it Terry or Jennifer was doing that? But yes, I will talk to Joy about that.
Okay. Thank you. Thanks,
You're welcome.
everybody.
You bet.
Here we go.
Gail, I've got another question.
Uh-huh, go ahead.
This is Matt Williams.
I'm Matt.
Hey, so when you have the medical necessary ones, who is the ultimate determiner that the student is in a medically necessary situation for one of those centers?
Well, I guess I would have to say it's the Department of Health, because a child can't be designated as medically necessary without the Department of Health's Medicaid approval. That said, if you think about it, a parent can place a child in a residential treatment facility. You know, that's every parent's right?
Sure.
That doesn't if it's a unilateral parent decision to place a child, and let's say FAPE is not at issue, right? It's, you know, they feel the child needs that kind of treatment. It really changes the conversation, because at that point, just like placing a child in a private school or homeschool, FAPE is off the table, right?
Mm-hmm.
And the parent, the student's rights and protections under IDEA are no longer relevant, and the district would develop a services plan. So it's the Department of Health approval piece that puts these students in this category, that requires the district to maintain primary enrollment and responsibility for FAPE. Do you see what I'm saying? Did that answer your question, Matt?
Yeah, I believe it did.
Okay. Yeah, without that Department of Health approval, they don't qualify under this statute, and so none of this would apply.
That was a great question, Matt, and we ran across that in our own research, and that caused us to like really divide out this document some. So it really is that Department of Health certification that it's medically necessary and that Medicaid's going to pay that moves a child into this realm.
Yeah, without it, they don't qualify for this designation.
Yeah, and I've never experienced that, so I'm assuming the Department of Health then sends that certification to me or to the district?
Actually, the facility, the PRTF would send a letter, I think is how that works. They would notify you, asking you within 7 days to make a decision about how you want the education services delivered.
Gotcha. Okay. All right. Thank you.
That is correct.
Any other questions? Hi, Bart.
Hi, Gail. I don't have a question. I just wanted to say thank you for your work on this and
You're
the
very
presentation.
welcome.
So
My pleasure.
excellent.
My pleasure. It's good to see you.
Good to see you too.
Okay, I've got 10 minutes after 12. Not hearing other questions, I think we will go ahead and end the meeting. Thank you again, all of you that are still on the call. We appreciate you. And if you do have a question, but you didn't want to ask it, feel free to give me a call or shoot me an email. Thank you very much.
Thanks, everybody. Great job, Gail.
Thank you, Margie. Thank you, everybody, and my WDE colleagues.